from the drama-free true crime destination. No fluff, no filler, just the bites, breakdowns, and bold truth you need. This is the Mid-Week Byte. And welcome to the Mid-Week Byte, one and all. Ernest Bethea, the last Outlaw, on a Thursday evening. So good to have you all here for this edition of the Mid-Week Byte. And I want to begin with my opening statement, but within it contains a little bit of breaking news as of yesterday. So with that being said, let's go ahead and let's begin this edition with my opening statement. All right. This evening, we begin with a verdict that echoes far beyond one Texas courtroom. Yesterday, a jury found former Uvalde school officer Adrian Gonzales not guilty on all 29 counts of child endangerment and abandonment, a decision that will stir relief for some, heartbreak for others, and questions for all about what accountability looks like when lives are on the line. And as that verdict settles, the rest of our nation continues to confront its own tragedies. A father comes home from work to find his two sons gone and their mother in handcuffs. A Florida teen admits to stabbing his own mother to death as she slept. An ex-husband stands accused of murdering an Ohio couple found in their home. And a fire chief's fate is hanging in charge tied to betrayal and rape. Crime story where justice is tested. This is your Midweek Byte, and tonight we go deeper. So glad you can join us, ladies and gentlemen, to get things going. And we're going to start with that little piece of breaking news that I just touched on in my opening statement. Yesterday, a Texas jury finding Adrian Gonzales not guilty on all 29 counts of child endangerment and abandonment. I'm going to take you to the courtroom first, then I'll break the whole thing down.
Welcome back. The verdict is in Uvalde. There's a live look inside the gallery. Word from the courtroom is we're waiting for the defendant, Adrian Gonzales, the former police officer, to arrive inside the courtroom. And I believe when he gets in there, they will assemble everyone and deliver this verdict. And there's the defendant walking in. And, you take a moment to think about what this moment is like. Yes, he's not facing life in prison, but he is facing a potential 58 years. Someone who at one point was a police officer. His job was to serve and protect and put people into jail. And here he is now, moments away from finding out whether or not he will become a convicted felon and end up behind bars in prison.
All right, please be seated in the courtroom. Members of the jury, I've received information that you have a verdict. Could I have the presiding juror stand momentarily? Is that verdict unanimous, sir?
Yes, sir.
As to each of the 29 counts?
Yes, sir.
Could you hand it to the bailiff for me, and you may be seated? Could I have defendant and counsel please rise? All right, because number 25 FC 0001U, the state of Texas versus Adrian Gonzales. In each of the 29 counts, we, the jury, find the defendant, Adrian Gonzales, not guilty. You see it? All right, members of the jury, I want to thank each and every one of you for your close attention and your patience and being with us timely throughout this trial. I know it was not easy for you. I know everybody was drafted, nobody volunteered. It was a long endeavor, and I want to thank each and every one of you for being here. I'm going to ask you one more time to go with the bailiff to the jury room, and we'll release you from back there. But thank each and every one of you, and would everyone rise for the jury to be excused. All right, Mr. Gonzales, you were acquitted by the jury. Your lawyers can talk to you more about this, but you do have the opportunity within a timely manner to file for that expunction. They will tell you further about that, but it's incumbent on me to tell you that immediately after the verdict is returned. All right, we're in recess. Thank you very much. I'm going to tell them, folks, it's up to you. They're released from their instructions.
Adrian Gonzales has been found not guilty on all 29 charges. He'll go home tonight a free man. Was facing real time in prison for his alleged inaction on the day of the massacre at Robb Elementary School on May 24th, 2022.
If it took you as long to catch the shock of that statement, of that verdict, you're not alone. I know there are a number of families right now that are in a state of shock as well. Here's a breakdown. A jury acquitted former school resource officer charged in connection with the Uvalde school shooting of all charges. Former Uvalde School District Police Officer Adrian Gonzales was facing 29 counts of child endangerment and abandonment after 19 children and 2 teachers were killed in a mass shooting at Robb Elementary in 2022. Gonzales and former Uvalde Schools Police Chief Pete Arredondo were indicted by a grand jury in June 2024. They are the only 2 people indicted in the shooting. Gonzales was one of the first officers to arrive on the scene among more than 400 officers who responded and waited more than 70 minutes before confronting the shooter. Arredondo was the on-site commander that day, reported the Associated Press. He is charged with 10 counts of abandoning or endangering a child. Arredondo failed to identify an active shooting, did not follow his training, and made decisions that slowed the police response to stop a gunman who was hunting victims, according to the indictment. A trial date for Arredondo has not been set. Records surrounding the shooting revealed terrified students inside the courtroom called 911 as parents begged officers to go in. A tactical team of officers eventually went into the classroom and killed the shooter. Again, state of shock. But then again, his boss has yet to stand trial too. Although no trial date has been set, Pete Arredondo, a former police chief, is set to go on trial to answer these charges as well. And he's been charged 11 times over. Will he suffer? Will he will be extended the same grace as the jury granted Gonzales, or will he be found guilty of those charges? We wait, we wait and see, because we're only halfway through with this. Like Vinny Politan said at the end of the clip, Adrian Gonzales gets to go home a free man. We'll have to wait to find out what's the fate of Pete Arredondo. All right. On to the rest of our docket. Former NICU nurse Aaron Stratman is pleading no contest to child abuse. Going to Henrico County, Virginia. A former NICU nurse pleaded no contest to 9 counts of felony child abuse involving 9 babies in incidents dating back to 2022. Aaron Stratman, who you see right here on your screen, had originally faced 20 counts in the case. A no contest plea means she denies intent to harm, but acknowledges that there is sufficient evidence to find her guilty. Multiple babies were found with broken bones in late summer 2023. Stratman was put on paid leave while Child Protective Services investigated, but no perpetrator was identified at that time. She returned to work, and within weeks, 3 more babies suffered broken bones. During court proceedings, prosecutors showed video evidence of Stratman pushing down on babies' legs and falling while holding a baby. Families cried in court as the evidence was presented. Stratman's attorneys said she was using a gas relief technique learned from other nurses, but prosecutors argued the technique is not appropriate for NICU infants. Her defense team also said Stratman loved being a nurse and never intended to cause harm. The Commonwealth's attorney, Shannon Taylor, said all 9 babies were mishandled and the plea ensures justice. The state will seek no more than 3 years behind bars, a sentence all families agreed to. Sentencing is set for June 5th at 11 a.m. And I really don't know what else to say to that. Excuse me. I mean, I know all the families agreed to 3 years for Aaron Stratman, but even then, that doesn't seem to be enough. I mean, 9 babies, infants. And she heard all of them this way. I like to see at some point a case where literally the judgment fits the crime. I like to, in Aaron Stratman's case, I like to see her endure the same pains those babies did. Now that, to me, that's justice. Next up, Susan Embert stood trial in her case, and this one we can file under justice served because she's been on trial 3 times for her husband's murder, and we are about to go into the courtroom for that verdict.
Breaking news, the verdict is in. Hello, everybody. I'm Matt Johnson in for Ted Rowlands on this busy Friday. Let's switch gears and head to the state of Georgia, where again, we have a verdict in the disguised as suicide murder trial. Defendant Susan Embert is on trial for a third time on charges that she murdered her husband, Jake. Jake was shot to death more than a decade ago, and Susan has maintained her innocence, claiming that he pulled the trigger on himself. Susan first went to trial back in 2019 when a jury found her guilty of all the charges, a conviction that would be later overturned 3 years later after a post-conviction attorney discovered that one of the jurors who convicted her was convicted himself, thus ineligible to serve on that jury. The second trial began last year, but was quickly declared a mistrial after the first day of testimony. The jury has reached a verdict. Let's head into the courtroom now and watch together.
All right. Good morning. I understand that you have a verdict.
That is correct, Your Honor.
All right. If you could hand it to I'll take a look. All right, and would the attorneys like to review it at the bench?
Yes, Your Honor.
Okay, I'll just let you all, the attorneys, come up for form. All right, I'm going to have Madam Clerk Johnson publish the verdict.
In the Superior Court of Georgia County, State of Georgia, State versus Susan Embert, case number 15R456. As to count 1, malice murder, guilty. As to count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 5, possession of a firearm with the commission of a crime, guilty. Dated the 16th day of January 2026. Signed by foreperson Reginald Bernard Hall.
All right, thank you. All right. Anything from the state or the defense?
Nothing from the state, Your Honor.
No, Your Honor.
Is there a request of any polling of the jury?
Just a moment, Judge. Yes, Your Honor.
All right. I'm going to now poll the jury. I'll ask each juror, was this your verdict? Was it freely given by you or voluntarily made by you? I'll go through each juror to make sure everyone is in agreement with the verdict. All right. I'm going to we'll start with foreperson and then go all the way around and go through. If you would stand up and just give us your juror number.
Jury number 39.
All right. Was this your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is this still your verdict?
Yes, Your Honor.
All right, next person. Thank you. Juror number?
24.
All right. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict? Next juror. All right. Was this your verdict? I'm sorry, your number, please. Thank you. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict? All right, next juror, give me your number, please. 15. Was that your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? All right, next.
Number 11.
Number 11. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you. Next juror.
Juror number 4.
Number 4. Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? Is it still your verdict? Thank you. Next person. Number, sir?
Juror number 10.
Number 10. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
It is.
Thank you. All right, next person. Number, sir? 31. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you? Is it still your verdict? Thank you. All right, number please. 28. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you? Is it still your verdict? Next. Number 32. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you? Is it still your verdict? And then you were 32, correct? Okay, next person.
Jury number 36.
36. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
And there's one other person, I can't remember. Okay, all right. Was that your verdict in the jury room?
Jury number 38.
Oh, yes, 38, thank you. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
All right. Thank you, members of the jury, for your service this week. Taking out 2 weeks of your life, I know, was taxing on you. And so we do, all of us, appreciate your service for the past 2 weeks. There is no requirement that you're free to go. We will give you a token. The pay is not pay. It's just a token of appreciation. It's no way to say we're paying you for all this time you've taken off of work, but there is a token of appreciation that you'll be given by the clerk. There is no requirement that you speak to anyone about the case. However, if you would like to speak to either the attorneys or the media, you can do so. That will be completely up to you. If you want to talk about the case, if you never want to talk about it for the rest of your life, now you can watch the news. Now you can watch. You won't be shown, but you will probably be seeing this case on other television shows in the future. Thank you again for your service. Again, you're free to go. You don't have to talk to anyone unless you would like to talk to someone. Thank you.
Thank you. Thank you.
Thank you.
Thank y'all for your service.
Oh, yes. I know. Court stabbing on it. Yes. Thank you.
Susan Embert, the 61-year-old who has been through 3 trials, convicted twice, talking to her attorney before she's remanded back into custody. She's been out on bail, shaking her head, rocking her chair, looking up during the polling of this jury. Convicted twice of all counts: malice murder, felony murder, aggravated assault, and using a firearm during the commission of a felony.
All right, I'm jumping right back in now. I had to wait for my echo to finish with the weather report for tomorrow. Getting back to Susan Embert's case, she is convicted of malice murder amongst all charges. Woman has been found guilty following her 3rd trial on charges that she murdered her husband. Susan Embert was charged with murder in the death of her husband, William Jake Embert, who was shot to death on June 28, 2014. Susan has maintained her innocence and has claimed that the victim pulled the trigger and killed himself. Susan was first tried in December 2019 when a jury found her guilty of all charges, which included malice murder, felony murder, and aggravated assault. She was sentenced to life in prison with the possibility of parole after 30 years, to be followed by a sentence of 15 years. 3 years after Susan's first trial, she was granted a new trial after her post-conviction attorney discovered that one of the jurors who convicted her was a convict herself and thus ineligible to serve on a jury. Susan's second trial began on December 3rd, 2025, but the judge was forced to declare a mistrial after the first day of testimony. The coroner, testifying for the prosecution, said that antifreeze made him change his ruling on the case from suicide to homicide. That single word was enough for a mistrial after the judge agreed with the defense that it was an explicit reference to inadmissible and highly prejudicial evidence that had already been excluded. The crux of this case is whether Jake Embert or defendant pulled the trigger. Okay. The crux of the case is whether Jake Embert or the defendant pulled the trigger. Susan's attorney wrote a motion for a mistrial. There is no eyewitness to Jake Embert's death. There has been no confession from the defendant. There are dueling theories from the proffered experts. Susan's third trial began on January 7th, and the jury reached a verdict on January 16th. Susan now faces a potential life sentence after being convicted of 4 charges, including felony and malice murder. She is scheduled to be formally sentenced on January 28th. And I was looking for a little something extra to add to this, but I guess that's all there is to it. 3 times was not the charm. She's found guilty. There's no two ways about it. January 28th, she will be formally sentenced for the murder of her husband. Ladies and gentlemen, that is justice served. All right, now we move onward, and a Florida teen is pleading guilty to stabbing his mother to death while she was sleeping. Let's get a look at this real quick. Ooh, 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 ooh. Okay. We're going to Miami, Florida for this one. Days before his murder trial was in a plea agreement with prosecutors. 15-year-old Derek Rosa had initially pleaded not guilty to first-degree murder charges on his mother's death. On last Friday, he appeared in court and pleaded guilty to a charge of second-degree murder. Judge Richard Hurst sentenced Rosa in line with the terms of the agreement, which will have him serve 25 years in prison, followed by 20 years of probation. Rosa was 13 when prosecutors said he brutally stabbed his mother, Irina Garcia, to death while she slept in her room in their Florida home. Also in the room was Garcia's newborn daughter, who was not hurt. Rosa called 911 immediately after the crime and admitted to the dispatcher that he had stabbed his mother multiple times. Prosecutor Jonathan Borst said in court that evidence collected by detectives showed Rosa had been searching for the best way to kill someone, and specifically looking for the carotid artery in the days before the attack. After stabbing his mother, Bohr said that Rosa took photos of his mother's body and a bloody selfie that he shared with a friend. Rosa's stepfather, Frank Ramos, offered an emotional victim impact statement. "For me, you are like a son," Ramos said, addressing Rosa directly. "Your mom was a loving mother, dedicated, and an excellent person. Losing her destroyed our family and changed our lives forever." When asked if he had any statement to make, Rosa said simply, "I'm sorry. That's it, Your Honor." After handing down the sentence, Judge Hurst noted the intense interest the case had garnered, noted that there were more than 250 people watching the proceedings online. "I just want to make an observation as we close this case," he remarked. "The quality of advocacy on both sides of this case, the quality of the lawyers has been excellent. I believe this resolution is appropriate." In a statement following the hearing, State Attorney Catherine Fernandez Rundle said, "The pain Irina Garcia suffered from the 46 stab wounds could only have been surpassed by the knowledge that the person killing her was her own young son." Under the terms of Rosa's sentence, when he is released from prison after 25 years, he will be evaluated by a court to determine what, if any, mental health needs he may have. That could include residential mental health treatment for up to 6 months. So, Derek Rosa is going to prison for the next 25 years, will be on probation for 20 years afterwards, and may have to have 6 months of mental health treatment. I'm not seeing the justice here. I'm not. I mean, it's your mom. It's your mother. You're 13 years of age and you're stabbing her to death 46 times. And then you had enough sense to pick up a phone, call 911 and say, "Yes, I did it. I'm sorry, but I don't see the justice in this." He should have, if anything, instead of waiting for a plea deal to come down, he should have pled guilty in the first place. But that's just how I feel about it. Moving on. Ex-husband indicted in the murder of an Ohio couple found in their home. All right, here we go. We're going to Columbus, Ohio. An Ohio grand jury has indicted a man in the double homicide of his ex-wife and her husband, who were killed in their Columbus home last month. Court records show a Franklin County grand jury charged Michael murder and aggravated burglary while using a firearm suppressor. A 39-year-old McKee was a vascular surgeon who was living in Chicago and is charged in the shooting deaths of 39-year-old Monique Tepe, from whom he was divorced in 2017, and dentist Dr. Spencer Tepe, age 37, in their home on December 30th. No attorney for McKee was listed on the court documents. Authorities apprehended McKee in Rockford, Illinois last weekend. The hospital where he worked, OSF St. Anthony Medical Center, said it is cooperating with the investigation. He is currently being held after he waived his right to an extradition hearing on Monday. His next hearing in Winnebago County, Illinois, is scheduled for January 23rd, tomorrow. Columbus Police Chief Elaine Bryant said in an Associated Press interview on Wednesday that authorities now believe that McKee was the person seen walking down a dark alley near the Tepe's home in video footage from the night of the murders. His vehicle has also been identified traveling near the house, and a firearm found in his Illinois residence also matched evidence at the scene, she said. Authorities have not disclosed what type of firearm was used in the slaying. His arrest Saturday attracted national attention, capping off nearly 2 weeks of speculation surrounding the mysterious killings. No obvious signs of forced entry were found at the Tepe's home. Police also said no weapon was found there, and murder-suicide was not suspected. Nothing was stolen, and the two couple's young children and their dog were left unharmed in their home. Chief Bryant said police are encouraging the public to keep the tips coming. She said emails, phone calls, and other messages left with CPD helped them gather enough evidence to make an arrest. We want to thank our community specifically for stepping up, reaching out, giving us the information, and being open to sharing that with us. It has been tremendous. So I guess the next thing that we wonder is how much of that evidence is going to stack up to possibly put Michael David McKee behind bars. And what's the whole thing about killing his ex-wife? I mean, they've already divorced. What else could he possibly want? We'll just have to find out once all this thing goes to trial. Next up, the defendant in Charlie Kirk's killing. He's asking a judge to disqualify the prosecutors. Disqualify the prosecutors? All right, let's see what we got here. We're going to Provo, Utah. The Utah man charged with killing conservative activist Charlie Kirk returned to court last Friday as his attorneys sought to disqualify Paul in the case attended the rally where Kirk was shot. Defense attorneys say the relationship represents a conflict of interest after prosecutors said they intend to seek the death penalty against Tyler Robinson for aggravated murder. 22-year-old Robinson has pleaded not guilty in the September 10th shooting of Kirk on the Utah Valley University campus in Orem, Utah, just a few miles north of the Provo courthouse. The director of a state council that trains prosecutors said he doubted the disqualification attempt would succeed, and he was unaware of any major case where attorneys had been disqualified for bias. I would bet against the defense winning this motion, said Utah Prosecution Council Director Robert Church. They've got to show a substantial amount of prejudice and bias. The 18-year-old daughter of the prosecutor who attended the event where Kirk was shot later texted with her father in the Utah County Attorney's Office to describe the chaotic events around the shooting, according to court filings and testimony. Robinson's attorneys say the close connection between the prosecution team and a person present for Kirk's killing raises serious concerns about past and future prosecutorial decision-making in this case, according to court documents. They also argue that the rush to seek the death penalty against Robinson is evidence of strong emotional reactions by the prosecution and merits the disqualification of the entire team. Defense attorney Richard Novak urged Judge Tony Graff on Friday to bring in the state attorney general's office in place of the Utah County prosecutors to address the conflict of interest. Novak said it was problematic for county prosecutors to litigate on behalf of the state while defending their aptness to remain on the case. Utah County Attorney Richard Gray replied that Novak's last-minute request was aimed at delaying the case against Robinson. This is ambush and another stalling tactic to delay these proceedings, Gray said. Several thousand people attended the outdoor rally where Kirk, a co-founder of Turning Point USA, who helped mobilize young people to vote for President Donald Trump, was shot as he took questions from the audience. The daughter of the deputy county attorney did not see the shooting, according to an affidavit submitted by prosecutors. While the second person in line was speaking with Charlie, I was looking around the crowd when I heard a loud sound, like a pop. Someone yelled, "He's been shot," she stated in the affidavit. The child, a student at Utah Valley University, later texted a family group chat to say, "Charlie got shot," in the aftermath of the shooting. She did not miss classes or other activities and reported no lasting trauma aside from being scared at the time, the affidavit said. Prosecutors have asked Judge Graff to deny the disqualification request. Under these circumstances, there is virtually no risk, let alone a significant risk, that it would arouse such emotions in any father prosecutor as to render him unable to fairly prosecute the case, County Attorney Richard Gray said in the filing. Gray said the child was neither a material witness nor a victim in the case, and that nearly everything the person knows about the actual homicide is mere hearsay. If the Utah County prosecutors were disqualified, the case would likely shift to prosecutors in a county with enough resources to handle a big case, such as Salt Lake City, or possibly the state attorney general's office, said prosecution counsel director Church. Judge Graff would have the final say, he said. Prosecutors have said DNA evidence connects Robinson to the killing. Robinson also reportedly texted his romantic partner that he targeted Kirk because he has had enough of his hatred. At the school where the shooting took place, University President Astrid Tumenes announced Wednesday that she will be stepping down from her role after the semester ends in May. The State University has been working to expand its police force and add security managers after it was criticized for a lack of key safety measures on the day of the shooting. Prosecutors are expected to lay out their case against Robinson at a preliminary hearing scheduled to begin May 18th. Now, honestly, even I have to agree about that this could be a stalling tactic to delay the case further. Honestly, they might as well just go ahead, get this over and done with, and let's see where justice and fate meet. We'll see what the preliminary trial brings up on May 18th. Next up, the Alexander brothers are on their way to trial on federal sex trafficking charges. And we're going back to my old stomping grounds, New York City. Two real estate brokers and their brother are scheduled to go on trial in New York City on sex trafficking charges Tuesday, just days after their lawyers renewed their request to a New York judge to toss out charges that they sexually abused dozens of women over the course of a dozen years. Jury selection was was expected to last about 2 days, with opening statements scheduled for next Monday for a trial projected to last until early March. In papers filed in Manhattan federal court on Saturday, defense lawyers complained that prosecutors have unfairly treated their clients by rewriting the indictment as recently as last week and by recently adding charges the defense has not had time to investigate. The latest iteration of the indictment was filed last Thursday, the third time in 2 months that prosecutors have updated an indictment that accuses Orrin, Tal, and Alon Alexander of showering women with free travel and luxury accommodations before drugging and raping them in vacation destinations like New York's Hamptons. Orrin and Tal Alexander were luxury real estate moguls for over a decade before co-founding a real estate firm, Official, which specialized in high-end properties in Miami, New York, and Los Angeles. Orrin and Alon Alexander are 38-year-old twins, while Tal Alexander is 39. Alon, who went to law school, was an executive at his family's security firm. Defense lawyers acknowledge that the men had sex with women, but say the women were willing participants. The brothers have been held without bail since the December 2024 arrest in Miami, where they lived. All three have repeatedly pleaded not guilty to all charges. Prosecutors say the brothers typically met their victims on dating apps, through social events, at bars and nightclubs, and sometimes through party promoters before providing drugs, including cocaine and psychedelic mushrooms, or drugging their drinks before sexually assaulting them. Defense attorneys urged Judge Valerie E. Caproni to drop some charges from consideration at this month's trial if she doesn't toss them out entirely, including a conspiracy count in which the description of the charge was largely reduced in size. The defense should not be forced to trial on a conspiracy count. That was changed at the last minute, the lawyers wrote. Caproni has shown some sympathy for the defense protest of 11th-hour changes to the indictment. On Friday, she denied a January 12th request by the government to call a witness at trial to support a conspiracy charge, saying the request came well after an October 17th deadline to notify the defense of evidence in the case. Caproni has also ruled that Alon Alexander could not use his 2019 engagement and later marriage as proof he had quit the alleged conspiracy to sexually attack women. The lawyers also objected to forcing Orrin Alexander to go on trial on short notice on a sexual exploitation of a minor charge that would carry a mandatory minimum of 15 years in prison term if he was convicted. Prosecutors allege that Orrin Alexander in April 2009 persuaded or coerced an incapacitated female who was just 17 years and 10 months old to engage in sexually explicit conduct that could be filmed. The defense lawyers say her birth certificate can't be authenticated because it was issued by a former Soviet republic that is now in a war zone. The defense lawyers also attacked the premise of the government's sex trafficking charges, saying that prosecutors have taken the unprecedented position of that anything of value given to women to get them to a location where a sex act occurs can make it commercial sex punishable under a sex trafficking statute. The truth is, this is not merely a novel theory, It is an entirely new offense, not created by Congress, and not one remotely contemplated under the sex trafficking statute, they wrote. Meanwhile, the New York Times reported last week that a 45-year-old Australian woman who had accused Orrin and Alon Alexander of sexual assault was found dead near Sydney late last year. The newspaper said a spokesperson for the New South Wales Coroner's Office said the death was deemed to be non-suspicious. Whew. those brothers have got a lot to deal with coming up now, and they really, really have a lot to work with when it comes to their own defense. Let's just see how the rulings come out and when the trial will actually begin. Coming up, a police report says that a dad came home to find his two sons dead and their mother arrested. We are now going to Hillsborough, New Jersey, and there's a name that's going to be kind of hard for me to pronounce. So if I don't pronounce it right, just count it to my head and not my heart. A New Jersey mother is accused of killing her two young sons after their father discovered them unconscious inside the family's home on Tuesday. Priya Farsini Natarajan, age 35, was charged with 2 counts of first-degree murder and 1 count of third-degree possession of a weapon for an unlawful purpose in connection with the deaths of her sons, ages 5 and 7, according to prosecutors in Somerset County. Officials say Hillsborough Township Police responded to a 911 call at approximately 6:45 p.m. on January 13th. The caller, an adult male resident, reported that he arrived home from work to find his 2 children unconscious and that his wife did something to them, quote unquote. Officers found the 2 boys deceased in a bedroom inside the residence. Police and medical personnel attempted life-saving measures, but both children were pronounced dead at the scene. Natarajan was detained by Hillsborough police and transported to the Somerset County Jail. Authorities have not released the identities of the 2 children or the cause and manner of their deaths. An affidavit obtained by Patch said the children appeared to have been strangled. Now, I try to understand these cases. The more I follow them, the more I report on them here, Bethea'S Byte Reloaded. And whether it's children killing parents, parents killing children, I don't get it. I don't get it. This one has me totally rocked. Why would a mom strangle her 5 and 7-year-old sons, allegedly? What could they have done? What could they have done that's so horrible for that? We'll hopefully have answers to that one soon. In the meantime, a person of interest has been arrested as the search continues for a missing Arizona woman. Let's go to Avondale, Arizona right now, where police have arrested a person of interest as they continue to search for 21-year-old Isabella Comas of Avondale. On Monday, a turquoise alert was issued for Comas, and on Wednesday, police announced it was considered suspicious. Comas was last seen on Sunday, January 11th, at around 3 p.m. She is described as a Hispanic female, 5 feet 3 inches tall, weighing 110 pounds, with brown eyes and pink hair. She was last seen at a Quick Trip store wearing a white t-shirt with a black logo on the front, as shown in the surveillance photo released by police. This one. Comas was last seen driving a red 2011 Hyundai Sonata bearing an Arizona license plate 2EA6LW. The vehicle was later located near 67th Avenue and Indian School Road with no sign of Comas. Avondale police provided an update Thursday announcing they have identified a person of interest in the case and have spoken with him. He has been identified by authorities as 39-year-old Tommy Rodriguez. He was taken into custody on Thursday on charges related to the investigation into Comas's disappearance. He is facing charges for theft of means of transportation and criminal damages connected to the Comas's vehicle, according to the Avondale PD. Police say Rodriguez and Comas are romantically linked. Rodriguez is being held on those charges on a $50,000 secured bond. Scripps News Phoenix obtained court records showing Rodriguez has a lengthy criminal history, including serving over a decade in prison for second-degree murder. Oh boy. He also pleaded guilty in 2020 to stalking. Court records allege he threatened an ex-girlfriend with multiple weapons, including a machete and a hammer. Comas was reported missing after her friend was not picked up for work by her as usual. Officials say Comas did not show up for work on Monday, and no one was able to contact her by phone. Her phone was located through tracking and recovered. It was located at a recycling center in Phoenix on January 12th, according to police. Now, once again, this is where you guys could be of help. If you or anybody have any information on the details or whereabouts of Isabella Comas, you have anyone with that kind of information, you're asked to contact the Avondale Police Department. That number is 626-333-7001. 623-333-7001. Or you can call 911 without hesitation. But whatever you do, as we say here and all over the true crime community, please, if you see something, say something. That way we can do something. Let's either find Isabella or let's get justice for her. Next up, a Utah man standing. We're going to stay in Utah. A Utah man is standing trial after his brother-in-law allegedly lured him to death. Or excuse me, he was lured to his death. Back to Provo, Utah. A Utah man is standing trial on charges he killed his brother-in-law in a plot involving his sister. Ellis is charged with murder, obstruction of justice, and possession of a weapon by a restricted of death of Matthew Wistelli. Ellis admitted to pulling the trigger and shooting Matthew Wistelli, his brother-in-law, 7 times. But he maintains he was acting in self-defense. Ellis told detectives that he believed the victim had been armed with a knife. Detectives say the victim wasn't armed and had been lured to the property by Ellis's sister, Catherine Wistelli, who was also the victim's wife. Catherine had taken care of the couple's children from their California home to visit their mother. Text messages made clear that Matthew thought he was driving to pick them up and bring them home. Prosecutors say Catherine never planned to leave with Matthew and instead plotted with Ellis and their mother, Tracy Grist, to murder him when he walked through the door. A knife that was found in Matthew's hand at the scene was linked to a purchase made by Grist months earlier. Among the digital evidence, prosecutors have said they plan to planned to introduce internet searches conducted by the family related to the Donald Adelson case. Adelson was the fifth person convicted in the murder for hire that killed her former son-in-law, FSU law professor Dan Markell. Ellis and Grist's cases were severed in 2025, with the judge deciding that Ellis's case would move forward. Catherine pleaded guilty to murder and conspiracy charges in September 2025 and was sentenced to 1 to 15 years in prison. She is expected to testify at both her brother's and mother's trials. Man. It's amazing what some people will do in order to get out of a situation, get their kids out of a situation, and it's even crazier that the lengths that they'll go through in order to get it done. We'll just have to wait and see what Kevin Ellis's fate will be at the end of this trial. Next up, I'll be forever punished. A Michigan mother offers apology for murdering her son. Here we go with another case of a parent killing their child. And for what? In fact, I'm gonna take you right to that moment where we hear from the mom and find out what fate is after convicted her son.
This is People of the State of Michigan versus Katie Austin Lee, case number 25-47529-FC. Today is the date and time scheduled for sentencing. I have provided opposing counsel with the notice of appellate rights. I will also state for the record that Matthew Pickart, the victim's father, is present in the courtroom with some other family members. I confirmed with him that he does not wish to make a statement to the court regarding the sentence, but of course he's in the courtroom listening to the sentence.
Thank you, Your Honor. I have reviewed the pre-sentence investigation report with Ms. Lee. We do have a couple corrections in additions to make to the report. As far as the SSIR, Your Honor, PRV4 is currently scored at 2 points. We believe that should be at 0 points. If correctly scored, the total PRV should be 25 points.
No objection.
Also, Your Honor, for the offense variables, OV3 is currently scored at 50 points. We believe that should be at 25 points. If correctly scored, Your Honor, that should change the total OV to 140. It doesn't change the guidelines.
No objection. I made both those changes.
Thank you. And as far as the body of the report, Your Honor, there are some additions and corrections to make. In the report, it indicates that Ms. Lee is one of 2 children. We'd like 2 to be changed to 3. That's on a couple of pages. I did inform the agent on that to make those corrections. And lastly, on evaluation and plan, Your Honor, last paragraph, we'd like daily contact with her mother to be added to the report.
No objection. We made those changes.
Other than that, Your Honor, we don't have any additions or corrections to make.
Elocution.
Is prosecution?
Your Honor, you are well aware of the facts of this case that are presented in the pre-sentence investigation report and those obtained at the time of the plea. The plea agreement does involve a sentence agreement of a minimum of 60 years in the Department of Corrections with a maximum of 90 years on counts 1 and 3. The people ask the court to follow that agreement.
Your Honor, as far as the defense team here, our office has gotten to know Miss Lee here for over the last year. And one thing that she has made very abundantly clear was her love for her son, Austin. Katie was a single parent, trying to raise her son the best way she possibly can. She's not here to make excuses. This indeed was a tragic situation, and she has taken responsibility for that. As a single parent, she was doing everything she can for Austin, getting him the services that he needed. But in doing that, Your Honor, she neglected to take care of herself. So through that, with the combination of ignoring her mental health, being isolated from her friends, her family, and society, being cooped up in her apartment with her son once COVID hit, not leaving, and then going down, the multiple rhetorics online and what social media did, this is where we are today. Getting to know Katie, it has taught me a lot of things. Always check in with your loved ones, prioritize your mental health, and that's what I take from Katie over the past year meeting with her.
Ms. Lee, have you had an adequate opportunity to read and review the pre-sentence report?
I have.
Any additions or corrections to make besides the ones that your attorney's already made?
No.
Anything that you would like to say before sentence is imposed?
Yes.
Go ahead.
How does someone start something so important when words can only convey so much? I decided on where it means the most to me. My love for Austin. I love him with all that I am. It's endless and my heart is broken. It was just us for 18 years, and through it all, he's my baby, my rock, and my purpose. I fought as hard as I knew how for him to be included. There was never supposed to be a world where I am in it, but he is not, and I am so lost without him. I've thought about writing the statement for a year now, and all words fall short. I would like to apologize to the first responders who had to process that night, and the ones I held the knife up to. I'm sorry. It was unfair of me to put you in that position. I'm sorry to the detectives for the unanswered questions and to the hospital staff for being so angry. You saved my life. I'm sorry to the prosecutor for having to fight on Austin's behalf and to the defense team for the hard talks and the tears over the year. To the community I had a ripple effect out to. I never imagined it would hurt. The hurt would spread so far. To Matt, for taking him before you were able to fix your relationship. Mostly to our friends and family, and the friends that are family. I'm sorry for blindsiding you with such heartache. I can only begin to imagine what this has put you all through. I know there are no magical words to make it better. I've started 100 letters trying to, but it never seems right. I guess because nothing will be right again. At the time, I was too sick to see past our own pain and fear to grasp how much it would hurt the ones we love the most. Being suicidal is really good at that. Because of my health, the shame and the paranoia, there was so much I wasn't telling anyone. Out of fear of losing Austin, and I see now that would have been best, but I didn't think anybody would ever love or understand the way I could. Starting in 2020, my already struggling mental and physical health declined to the point we are no longer leaving the house except for doctor's appointments. After 5 years of not being out in the world, it became really hard for me to tell what was real and not real with the algorithms on my phone being nothing but the world is ending content. I fell so deeply into an echo chamber that we were living in a different reality, and it was a terrible one. I had managed to keep my head above water, but barely. In November 2024 is when I drowned. My mental health rapidly declined. I began to think the FBI was watching me from across the street. I would spend 8 hours a day watching out of my bedroom window trying to decode people's behavior and prove myself right. I was checking all my outlet for bugs, and when I couldn't find any, I thought they were using mind-reading drones. My brain was broken. Thinking of what I think was a jumping off point, I started seeing videos about the government sending mentally ill to what they call wellness farms, and my brain broke. It very quickly turned into fear that they were coming to get us at any moment and taking us to concentration camps. All of this on top of my already declining physical health, my increasing chronic pain. I no longer knew how to protect Austin. My mind and body were in a state of survival, and I was failing. We were scared. We were alone, and our depression had an answer. Only after a year of therapy, medication, soul searching, and finding God can I now see that night for what it really was. I now see the influence I had on his decision making, and it haunts my every waking moment. I never intended for him to suffer in any way. In my broken thinking, I was saving him from it. Every day, every thought, every nightmare, every flashback, every moment without him, I'll forever be punished. But I know that's not enough. I will spend the rest of my life in prison trying to process what I could have done differently and how I could have reached out. And continuing to speak out about the warning signs that I so clearly see now, looking back. Now for me, the only thing scarier than life in prison is life without Austin. And I'm so sorry I gave everybody that sentence. Thank you.
Does that conclude your comments?
It does.
Thank you. Your comments are very appropriate. You recognize what you did. And by taking responsibility, you have spared the first responders from living what was a horrific scene, and you spared jurors from witnessing photographs or images of what must have been a very horrific scene. Because in reviewing just the pre-sentence investigation report, just reading it, the narrative was difficult because it was horrific, and frankly, the acts that you committed on that date were nothing less than pure evil. It is the sentence of this court on counts 1 and 3 that you be turned over to the Michigan Department of Corrections for a minimum of 720 months, that's 60 years, and a maximum of 1,080 months, that's 90 years. You have credit for 332 days. As pertains to count 2, the resisting and obstructing police officer charge, it is the sentence of this court that be turned over to the MDOC for a minimum of 16 months and a maximum of 24 months. You have credit for 332 days as well. By law, these must be concurrent. You must pay state cost, crime victim costs, and DNA fees that are required by statute. These are final sentences. You may file an application at the Court of Appeals regarding your conviction and sentence. If you are unable to hire an attorney, this court will appoint one to represent you at public expense. You need to fill out the paper you've been provided and return it within 42 days. That is all.
Thank you, Your Honor.
Reach that.
Justice served. While it seemed that on the surface that Katie Austin Lee was taking accountability for what she'd done, the judge gave her the harshest sentence I've heard since I've started following true crime cases within the community like this. Michigan woman offered a tearful apology in court at her sentencing after she pleaded guilty to murdering her teenage son. Katie Austin Lee was sentenced to 60 to 90 years in prison as part of a plea agreement after she pleaded guilty to second-degree murder, torture, and resisting and obstructing officers in the death of her son, Austin Pickard. Lee admitted she killed her 17-year-old son after her mental illness spiraled. Starting in 2020, my already struggling health declined to the point we were no longer leaving the house, Lee said at Monday's sentencing. After 5 years of not leaving the house, it was really hard for me to tell what was real and not real, with the algorithms on my phone being nothing but the world's ending content. Lee said that before she took her son's life, she was spending 8 hours a day watching out her window, believing the FBI was watching her. She says she checked the outlets in her home for bugs. My brain was broken, she said. Lee began to cry as she offered apologies to the attorneys in the case, first responders who came to the scene, and her friends and family. Every day, every thought, every nightmare, every flashback, every moment without him, I'll forever be punished, she said. But I know that's not enough. I will spend the rest of my life in prison trying to process what I could have done differently. Getting to know Katie has taught me a lot of things, her attorney Brandon Bartholomew said in court. Always check in with your loved ones. Prioritize your mental health. Judge John Holsings expressed no sympathy as he handed down the sentence. Just reading the narrative was difficult because it's horrific, he said. Frankly, the acts you committed on that day were nothing less than pure evil. And I gotta agree with what the judge said in that. I have to agree with what the judge said in that because let me start by making this admission. First of all, I suffer with generalized anxiety disorder. I am grateful that I have a support system that checks in on me. I'm grateful that I have other outlets that I can access to get my mind in a place where I can bring my tone down. I won't have to assume the worst of everything. And knowing this, generalized anxiety disorder does not control me. It doesn't control Ernest Bethea in his life. It doesn't control Ernest Bethea when he's out these doors of his apartment. It doesn't control me when I'm at work. And it definitely doesn't control Ernest Bethea, the last outlaw, when I'm doing reports like this. And also on top of that, if I may be so bold, I'm also a big fan of a certain game show and a certain game show host. And every day as he signs off on his show, and you'll probably figure it out who it is as I say this. He always tells you to take care of yourself, especially your mental health. It is a good thing to get help when you need it. And now I can advocate for that as well. If you need the help, get the help. It's not a bad thing. You can do it's helpful to you. It's helpful to your family. It's helpful to your work life. It's helpful to you all around. In the meantime, as far as Katie, Austin, as far as Katie Austin League is concerned, this is definitely justice served. All right. Next up, actor Timothy Busfield was due in court for detention hearing in his sex abuse case. Oh, but we got an update now that he's been released from a New Mexico jail pending trial. We're going to Albuquerque with this story. Actor Timothy Busfield was released from jail Tuesday night in New Mexico, where he's facing counts of child sexual abuse. Hours earlier, Busfield's attorney successfully argued that the actor, best known for appearances in The West Wing, Field of Dreams, and 30-something, wasn't a danger to the community and shouldn't be behind bars while he awaits trial. Prosecutors sought to keep him in jail, outlining what they said was grooming behavior and abuse of power by Busfield over 3 decades. State District Court Judge David Murphy said while the crimes Busfield is accused of inherently are dangerous and involve children, prosecutors didn't prove the public wouldn't be safe if he was released. There is no evidence of a pattern of criminal conduct, and there are no similar allegations involving children in his past, Murphy said. Rather, this defendant self-surrendered and submitted himself to this court's jurisdiction, demonstrating compliance with the court for his arrest. Outside the courthouse, Busfield's wife, actress Melissa Gilbert, thanked Murphy for the ruling. She also thanked friends, relatives, co-workers, and strangers who she said have showered their family with love. Gilbert, who played Laura Ingalls in the 1970s to 80s TV series Little House on the Prairie, sat behind Busfield during the hearing. He was handcuffed and dressed in an orange jail jumpsuit. Prosecutors declined to comment on the ruling. Busfield is facing 2 counts of criminal sexual contact of a minor and 1 count of child abuse while working as a director on the set of a TV series The Cleaning Lady, allegations that he denies. He was booked into jail after a warrant was issued for his arrest, and he turned himself in. According to the criminal complaint, an investigator with the Albuquerque Police Department said a boy that Busfield reported that Busfield touched him on his private areas over his clothing on one occasion when he was 7 years old and another time when he was 8. The boy's twin brother told authorities he was also touched by Busfield, but he did not specify where and didn't say anything because he didn't want to get in trouble, the complaint said. During the hearing, Busfield's attorneys pointed out that the children initially said during interviews with police that Busfield didn't touch them inappropriately. Busfield's attorneys then accused the boys' parents of coaching their children toward incriminating statements after the boys lost lucrative roles on the show. Busfield's defense team called just one witness, Alan Caudillo, director of photography on The Cleaning Lady, to testify that children were on set, were never left alone with individuals, and that the parents were the ones who encouraged hugs with adults on the set. According to the criminal complaint, one of the boys later disclosed during a therapy session that he was inappropriately touched by Busfield. Those records were obtained by police during the investigation. Assistant District Attorney Savannah Brandenburg-Koch called evidence of abuse against Busfield strong and specific. She also said witnesses expressed fear about potential retaliation and professional harm. The boys' allegations are supported by medical findings and by their therapist, Brandenburg-Koch said. Their accounts were specific and not exaggerated. Arguing for Busfield's release, defense attorney Amber Fairberg said her client will be under intense scrutiny because of publicity surrounding the charges. That bell can't be unrung, Fairberg said. The idea that he, Busfield, could then go out and be dangerous with a child in a world where everybody knows who he is absurd. Busfield submitted letters vouching for his character, and his attorneys say he passed an independent polygraph test. Legal experts say New Mexico is among a few states that allow polygraph evidence in criminal cases, but a judge has final say over whether one can be used. There are strict requirements for admission in court. Well, here's another case where either the boys are being coached or Timothy Busfield actually did what he's being accused of. We'll just have to wait and see what becomes of this as this case goes forward. But for now, I'm praying for everybody involved. Okay, next up. A teen is going to plead guilty to a North Carolina shooting that killed 5 people. North Carolina. Let's see where we're going here. Raleigh, the capital. An 18-year-old plans to plead guilty to a 2022 mass shooting in North Carolina that left 5 people dead, including his older brother, avoiding a trial next month, according to his attorneys on Tuesday. A written notice filed in Wake County Court by the lawyers for Austin Thompson said their client intends to plead guilty to all charges against him. Thompson was 15 when authorities believe he went on a killing rampage on October 13, 2022, beginning in his Raleigh neighborhood with his 16-year-old brother. A hearing ahead of his scheduled February 2nd trial had been set for Wednesday. But through the intended plea, Thompson has decided he wishes to save the community and the victims from as much additional infliction of trauma as possible, attorneys Kelly Manette and Deontay Thomas wrote. The attorneys didn't immediately respond to emails seeking additional information on the decision. Thompson's legal proceedings were delayed in part as he recovered from a gunshot wound that a prosecutor concluded was self-inflicted before his arrest. His attorneys say it resulted in a brain injury. Prosecutors have not revealed a potential motive for the shootings, but in a court filing said they had intended to prove Thompson's actions, among other factors, were especially heinous, atrocious, or cruel, and that he attempted to avoid custody. Tuesday's filing by Thompson's attorneys said that while the serious brain injury he suffered has made it such that Austin cannot explain why he committed the shooting, he has always accepted that he did this. Thompson was charged as an adult on 5 counts of murder, 2 counts of attempted murder, 2 counts of assault with a deadly weapon, and 1 count of assault of an officer with a gun. A sentencing hearing would be held at a later date after any plea. Because of his age and at the time of the attack, Thompson could not receive the death penalty if convicted. The presiding judge would have to decide whether to sentence him on murder counts to life in prison without parole or with the possibility of parole after at least 25 years. Wake County District Attorney Lauren Freeman said Tuesday that she was aware of the plea and notice. "We are ready to move forward. Our thoughts are with the families of the victims," Freeman added in a text message later. Thompson hopes that the material presented at the sentencing hearing brings as much peace and closure as possible, his attorneys wrote. Prosecutors contend that Thompson shot and stabbed his brother James, whose body was found in their home. Police also said they believe Thompson then shot multiple neighbors on the Hennington community streets, killing off-duty Raleigh police officer 29-year-old Gabriel Torres and 52-year-old Nicole Connors. Another neighbor who was wounded survived. They also alleged that he later fatally shot 2 others on the nearby Neuse River Greenway Trail. 34-year-old Mary Marshall, and 49-year-old Susan Carnatz. Dressed in camouflage with multiple weapons strapped to his belt, Thompson was located by law enforcement in a shed nearby and arrested after an hours-long standoff that resulted in another police officer being wounded. Thompson's attorneys had indicated last year that they intended to use diminished capacity and voluntary intoxication of a prescribed medication in his defense. In 2024, Thompson's father pleaded guilty to improperly storing a handgun that authorities said was found with his son after the shootings. He received a suspended sentence and probation. Investigators seized 11 firearms and 160 boxes of ammunition. Some of them were empty from the Thompson home, according to search warrants. Now, of all the things you can do leading to a possible murder, this was just, I really don't know what to say at this point. I really don't know what to say at this point. All I know is he's pleading guilty, and who knows? It's in the judge's hands at this point whether he'll be sentenced to life without the possibility of parole or life with the possibility of parole after 25 years. Either way, it's still gonna end up coming back as justice served, some form or another. Next, we're going to Washington for verdict early this week in the cheating fire chief murder trial. Former fire chief Kevin West is on trial for the murder of his wife. So now we take you right to the courtroom to get the verdict in.
Welcome back, ladies and gentlemen. Juror number one, I see you have some documents in your hand. Are you the presiding juror?
Yep.
The jury reached a verdict?
Yep.
Would you hand the documents then to the committee? All right, verdict in count 1A. We, the jury, find the above-named defendant guilty of the crime of murder in the first degree. Verdict count 1B is blank as required. Verdict count 2A, we, the jury, find the above-named defendant guilty of the crime of murder in the second degree. Special verdict form were Kevin West and Marcel West intimate partners. Answer yes. All right, so I'm now going to poll you to make sure that these are your individual verdicts and that they were the verdicts of a unanimous jury. So I'm going to ask you those two questions. Were they your individual verdicts, and were they the verdicts of the jury? If you would answer no to any of the counts, be sure to let me know. So juror number one, were these your individual verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number two, were these your individual verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number three, were these your verdicts? And were they the verdicts of the jury? Juror number four, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number five, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number six, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number seven, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number eight, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number nine, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number 10, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Juror number 11, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
And juror number 12, were these your verdicts?
Yes.
And were they the verdicts of the jury?
Yes.
Jury's been polled and found to be unanimous, and the verdict forms are signed and dated in proper form, so they'll be filed with the clerk. Ladies and gentlemen, I want to thank you for your assistance in this case. We could not have a functioning jury system if citizens such as yourself weren't willing to take time out of your schedule to make these very important decisions for us. We know it's sometimes an inconvenience, and we do appreciate it. You're now released from the obligation that you not discuss the case. You're free to discuss it with whoever you like. In a couple of minutes, I'll be off the bench and stop by the jury room to see if any of you have questions or wish to make comments, and sometimes the attorneys do that as well. The flip side of that is that you are not required to discuss this case with anyone, and if I come to the jury room and find that not one of you wanted to spend one additional second there, I won't be offended in the least. In either event, you're discharged. Thank you again for your service.
That was earlier this week in Vancouver, where former fire battalion chief Kevin West was found guilty of first-degree murder and second-degree murder in the January 2024 death of his wife, 49-year-old Marcy West. Prosecutors argued that Kevin strangled Marcy to death in their home. Kevin called 911 on January 8th around 4:30 a.m. to report his wife was unconscious and having a seizure, according to testimony. She was pronounced dead around 5:11 a.m. In an interview with police, Kevin said the couple had a regular night watching movies and eating takeout before Marcy complained of a headache and took ibuprofen. Kevin told investigators that Marcy vomited before going to sleep but had no other complaints and decided to go to bed. A medical examiner noted injuries on Marcy's body consistent with strangulation, including bruises under her jawline and earlobes, brain swelling, and bilateral subcutaneous hemorrhaging on her neck, according to documents. Her death was later ruled as a homicide caused by asphyxia due to blunt neck trauma. An investigation further revealed that Kevin was having an affair with Cynthia Ward, whom he met in the early 2000s. Kevin initially told authorities he had no plans to leave Marcy. However, text messages recovered from his cell phone allegedly indicate he planned to move out of the home on January 8th and finish divorce papers the following day. Letters were also found in Kevin's garage addressed to Ward, including one that read, "Next year, 2024 will be our year. We will be together celebrating every day with love and understanding of what it means for you and I to be together. Our story will ring in the new year loud for all to hear." At trial, Kevin maintained he did not kill his wife. The defense argued Marcy suffered from untreated maladies for which she refused to seek treatment, including debilitating migraines. Attorney Brian Walker said an intense massage from Kevin's son before she died could have triggered a seizure, and that the failures of first responders may have contributed to her death. At the time of Marcy's death, Kevin was a battalion chief for the Kamas-Washougal Fire Department. Court documents and testimony revealed that since his arrest, Kevin and Ward had become engaged. Kevin faces life in prison at his sentencing scheduled for February 27th. I get it. We've seen and covered cases like this plenty of times here at Bethea'S Byte Reloaded. And I will say this again. if you had already, I mean, in Kevin West's case, if you already started on the divorce papers, and you still don't want to stay with the woman you're supposed to be married to, finish the divorce papers, file them, let it go, done. That'll save you the drama of being labeled a criminal defendant. But here we are. Now you're staring at a lifetime behind bars. Instead of wedding bells in your future, the only clanging you're going to be hearing is the clanging of that cell door. Oh, here's a good one. Mom charged with murder. Yeah, mom charged with murder, an attempted murder, after a deadly Thanksgiving dinner. Headed right back to North Carolina, Hendersonville, North Carolina, that is. A North Carolina woman is charged with murders that occurred 18 years apart. Gudrun Casper Leinenkugel. Again, if I pronounced it wrong, count it to my head, not my heart. That's my first time actually pronouncing that name. Anyway, she's charged with 2 counts of first-degree murder and 2 counts of attempted first-degree murder after what police described as an extensive and comprehensive investigation. Investigators say Gudrun, that's how I'm gonna refer to all the way throughout this report. Gudrun hosted a 12-person Thanksgiving dinner in November 2025, where she poisoned a bottle of wine that she served to her 2 daughters and one of their boyfriends. That's according to WHNS. Prosecutors said Gudrun added acetonitril, if I'm pronouncing that incorrectly. Again, head count it, heart don't. added acetonitril to the bottle before serving it. According to the Environmental Protection Agency, acetonitril is primarily found in air from automobile exhaust and manufacturing facilities. It's used as a solvent for spinning fibers and in lithium batteries. When ingested by humans, the body converts the substance to cyanide, potentially causing poisoning. The North Carolina State Bureau of Investigation announced charges against Gudrun for the murder of Leila Davis and the attempted murders of Richard Pegg and Mia Lacey. While investigating the deaths, detectives found evidence linking Gudrun to the 2007 murder of Michael Schmidt, who died in a house fire, and charged her for that as well. At a bond hearing, prosecutors revealed they are continuing to investigate additional deaths that could be tied to the defendant. Again, that's according to WHNS. Gudrun is due in court next for a probable cause hearing on February 10th. And this is one of those cases that I'm still trying to make heads or tails out of. Okay. Well, once I am able to make heads or tails out of it, and I can get more information, I'll be sure to bring that information to you. And finally, Ashley Buzzard's defense team has granted access to sealed warrants in her murder case. Back to Lumper, California. A permanent gag order will remain in effect during the remainder of criminal proceedings against the Vandenberg village mother charged with murdering her 9-year-old daughter last fall. Santa Barbara County Superior Court Judge Stephen Dunkel approved the order during a hearing for 40-year-old Ashley Buzzard on Wednesday morning in a Olympic courtroom. The ruling came after county counsel representing the Santa Barbara County Sheriff's Office and the prosecution told the judge they were taking no position on the request. The defense requested the gag order be placed on the Santa Barbara County Sheriff's Office in an effort to prevent authorities from releasing additional details about the murder investigation involving Buzzard. Buzzard is charged with shooting her daughter Melody in the head multiple times and leaving her body in a rural area of Wayne County, Utah, while the two took a 3-day road trip last October. The sheriff's office said Buzzard was uncooperative with the months-long missing person investigation involving Melody ever since it was launched on October 14, 2025, after school administrators notified authorities about the girl's prolonged absence. Buzzard was arrested on December 23rd after her daughter's remains were discovered and DNA results confirmed. In court on Wednesday, Judge Dunkel also approved a defense motion for access to sealed search warrants and affidavits in the case. The request will also apply to any future warrants filed under seal. At the defense's request, Buzzard waived her time for another month, now extending through April. This means her preliminary hearing will not take place before then, as her public defender, Erica Sutherland, told the court she is missing a significant amount of discovery, which she described as essentially all forensic evidence. Sutherland asked that Buzzard's case be put on the calendar for February 11th so an update can be provided then on when the defense can expect the requested documents from the prosecution. Buzzard appeared in court dressed in black slacks and an orange top. Her short, blonde, curly hair was partially pulled back into a ponytail during the brief hearing, where she sat alongside her public defender and only said yes when confirming to the judge that she was waiving her time. Buzzard has pleaded not guilty and is being held in the Northern Branch Jail in Santa Maria without bail. This is the case that I am definitely keeping my eye on. I am definitely keeping my ear on, because this one is way too important not to follow. And now that takes care of my docket for the for this, but now it's time to go ahead and wrap this case up, wrap this edition up with my closing argument. And we had a doozy of a night, chock full of cases for over this past week. So where does this leave all of us? A not guilty verdict in Texas, families grieving in Florida, Ohio, North Carolina, and all across the country. Trials unfolding, verdicts pending, and communities trying to make sense of the senseless. Different cases, different states, different lives forever changed. But the same question rises from every story we've covered tonight. What does justice look like when the people we trust, the people we love, or the people we depend on fail us? Some answers come in the form of verdicts. Some come in the form of confessions. Some may never come at all. But here at Bethea'S Byte Reloaded, we don't turn away. We don't settle for the surface. We don't let the noise drown out the truth. We watch, we listen. We hold space for the victims, the families, and the communities left behind. And until the next development, the next verdict, the next twist in the pursuit of justice, we stay vigilant. Because this isn't just true crime coverage. This is accountability. This is clarity. This, as I say in my signature tagline, is Bethea'S Byte. And it's reloaded. And as always, the question isn't what happened. It's what happens next. I want to thank you all for joining me this evening. And I look forward to doing this with you one more time. You know how to get a hold. You know how to get a hold of me. If not, keep watching the screen. You can find all the ways you can. So let us go ahead and put the wrap on this thing. As always, this is your home for true crime news without the drama, where your opinions matter. Lively debates are encouraged. Your voice is heard, and above all else, justice is served. And how do we do it? Only one way. With no gimmicks, no drama, and no BS. I'm Ernest Bethea, the last outlaw, and this is Bethea'S Byte. And it's reloaded. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.